Off the top at 5, a developing story. A man accused of killing a woman could be on the verge of freedom, all due to double jeopardy. Because of that technicality, 66-year-old Gary Otis will not face trial on a charge of murder. Hello, I'm Sharon Reed.
And I'm Tracy Hutchins. We first covered this case 2.5 years ago after Otis was arrested on suspicion of killing a 75-year-old woman. Well, Frampton is at the state Supreme Court where this case was settled unanimously.
Almost as soon as the trial for Gary Otis began back in 2014, the judge ruled a mistrial. And that decision paved the way for the state's highest court today to decide that there will in fact be no trial. On the night of June 17, 2013, Atlanta police had little doubt as to what happened and how it happened. 75-year-old Mary Oliver was found stabbed to death in her bed inside this apartment complex in southwest Atlanta. Police quickly arrested one of Oliver's neighbors, Gary Otis. Investigators said he was covered in blood and was holding 2 bloody knives. Oliver's children spoke with us not long after receiving the news.
She just got out of the hospital. She had heart problems. And then for you to kick in her door to kill her, I don't understand that. That's not the way senior citizens are supposed to die.
But almost as soon as Otis's trial began the following year, he pleaded not guilty by reason of insanity. The prosecution objected, and Judge Earl Glanville declared a mistrial, something neither the defense nor prosecution had requested.
I've tried several murder cases in front of Earl Glanville. He's a fantastic judge. He does a phenomenal job, but no one is perfect, and this was a technical error that he made.
Defense attorney Jay Abt says this case is a rare example of how a technicality can allow a defendant like Gary Otis to walk without facing trial. It all hinges on Glanville declaring a mistrial when none was requested.
He made a ruling of declaring a mistrial on his own when there was no legal basis for the mistrial. Because a jury had already been picked, double jeopardy attaches. You cannot retry the case.
According to Professor Michael Mears at the John Marshall School of Law, the prosecution could file for a motion to reconsider, but it is likely to be denied because all 7 judges voted together in their decision, and because it is a state matter, the U.S. Supreme Court will not get involved. In downtown Atlanta, Will Frampton, CBS 46.